right, thanks for coming, everyone. My name is Tom Landy. I'm the director of the McFarland Center for Religion, Ethics, and Culture, and welcome to Ream Library today. The McFarland Center sponsors and supports a range of programming, including lectures, conferences, other special events, class visits that encourage dialogue about meaning, morality, and mutual obligation. You can learn more and find our schedule online, watch past events online at holycross.edu/McFarland Center, and this event will also be recorded and posted within a day or two. Today, I'm really pleased to welcome Professor Laura Briggs, an expert on child welfare policy, to speak about a really painful side of U.S. history, one often ignored and subsumed in other narratives, a long history of child taking in the United States. Many of us have been distressed in recent years by news of migrant children being separated from their families at the U.S.-Mexico border and seeing images of kids in cages as they await asylum hearings to be transferred to longer-term housing or reunited with their families, we hope. We assume that this is not the American way, that it's beneath us. And in many ways, it is beneath us. But sadly, it isn't uniquely cruel. The U.S. has taken children for political use purposes for 400 years. Laura Briggs details this history in a book published last year called Taking Children, A History of American Terror. As professor of women, gender, and sexuality studies at University of Massachusetts Amherst, she also teaches seminars on transnational feminisms, reproductive politics, and contemporary feminist theory. She's author of How All Politics Became Reproductive Politics, From Welfare Reform to Foreclosure to Trump, published in 2016. Somebody's Children, The Politics of Transnational and Transracial Adoption, published in 2012, and winner of the James A. Rawley Prize of the Organization of American Historians. And Reproducing Empire, Race, Sex, Science, and U.S. Imperialism in Puerto Rico, published in 2000. She's co-editor with Diana Mari of International Adoption, Global Inequalities, and The Circulation of Children, published in 2009, and recently issued a special issue of Meridians, Feminism, Race, Transnationalism on Radical Transnationalisms, Reimagining Solidarities, Violence, Empires. Her new book project, The Future is Born in Small Places, The Gendered Biopolitics of Freedom, Debt Imperialism, and Unnatural Disaster in the Caribbean, focuses on historical and contemporary uses of debt in the United States and in the Caribbean as a political tool of disenfranchisement, expropriation, and necropolitics. Professor Briggs' work has been featured in court cases, podcasts, and in popular media, including National Public Radio, PBS, the New York Review of Books, Slate, New Republic, Indian Country Today, and Ms. Magazine. She holds degrees from Mount Holyoke College, Harvard, and a PhD in American Studies from Brown University. So please join me in welcoming Professor Laura Briggs.
It's really a pleasure to be here with you, and thank you to Tom for organizing this. This is the first time in a year and a half I've been somewhere to do a talk. I've done a lot of talks on Zoom, which just is not the same. So it's just a pleasure to be in a room with actual humans. So the conversation about immigration to the United States has been haunted by the long history of taking children. Perhaps never more than when Jeff Sessions announced in 2018 that his Department of Justice would enforce a policy of zero tolerance of asylum seekers who presented themselves illegally at the southern border, calling them filth, and saying that he would take children to force them to withdraw their asylum claims. Even after the courts ruled repeatedly in 2018 that asylum seekers did not have to cross at any particular place in order to request asylum, members of the Trump administration continued to criminalize it. Across the same geography of the Southwest in the late 19th century, the United States fought wars against indigenous peoples and took their children as hostages for the good behavior of people in tribal nations. Native peoples and their children were held at military bases, just as many asylum seekers are. Fort Bliss, where numerous whistleblowers have called out the Biden administration for what they say is the abusive treatment of children seeking asylum, was founded in order to wage war against the Apache and Comanche nations. Biden was elected in 2020 in part on the strength of people's opposition to Trump's policies on immigration, on immigrants, refugees, and asylum seekers, especially the taking of what some have estimated as more than 6,000 children between 2017 and 2020. However, thus far, Biden's policies have looked more like Trump's than his campaign commitments might have led us to believe. Since Biden took office, 1.7 million immigrants and asylum seekers have been expelled under Title 42, part of the public health code that some claim allows the president unilaterally to implement disease control measures, COVID-19 in this case, even though many of those crossings should have had the right under U.S. and international law to petition for asylum. Ironically, most people who've been expelled got a COVID test before being deported, meaning that they're being expelled for potentially having an illness that Border Patrol knows they do not have. Those who test positive are held in the U.S. under agreements not to spread disease to Central America or elsewhere. Ruben Garcia, the director of Annunciation House, a migrant support center in El Paso, Texas, denounced this policy, saying, "What gave Donald Trump his wall was Title 42. That's been incredibly more effective than any physical barrier. This was never about the pandemic to begin with. This was precisely about border enforcement," he said. The political activists of UndocuBlack, part of the Black Lives Matter ecosystem, have urgently and persistently raised the question of the deportation of black migrants. Under Title 42, more Haitians were expelled in the first 2 months of the Biden-Harris administration than in 4 years of the Trump administration, including children, just as Haiti was experiencing an increase in political violence and in what is increasingly indistinguishable gang violence, as President Jovenel Moïse was assassinated after increasingly allying his power with the gangs. The original targets of the Trump administration child separation policy were largely from the Northern Triangle in Central America, Honduras, Guatemala, and El Salvador. And the Biden administration has also used what activists call the invisible wall of Title 42 to exclude those asylum seekers as well. It's also thus far done little to unmake the right-wing alliances of the Trump administration there. In El Salvador, wait a minute, that's not the, somehow my slides got out of order. In El Salvador, President Nayib Bukele is a Trump-like strongman, an authoritarian populist who makes for dramatic television and who has an extensive Twitter following, but who has also ousted members of the country's Supreme Court, threatened journalists, incarcerated anyone suspected of having COVID and dangerous disease-spreading quarantine centers, and sent the military against legislators. Throughout the region, gangs and cartels spread in the late 80s through the U.S. policy of backing right-wing governments and paramilitary groups like the Contras, including those who became involved in trafficking drugs into the U.S., arming them to the teeth and training them in torture and murder. Beginning in the mid-90s, the U.S. intensified the problem by deporting gang members from Los Angeles who had fled the war and regrouped in Los Angeles as Mara Salvatrucha 13 and Barrio 18. While there's also much to criticize in the Obama administration's record on immigration, it at least sought to support activists in Central America who tried to break growing links between the gangs and cartels and right-wing political leaders. In contrast, the Trump administration encouraged these uses of power, money, and policing. Indeed, his own administration could be said to be modeled on them, as we saw in his apparent efforts to send paramilitarized groups against the U.S. Congress on January 6th, or at a minimum did little to stop them, alongside the growth of white nationalist networks in the U.S. police and military, and in Trump's business enterprises' enrichment from his time as president. While the Biden administration itself is less financially corrupt, it has done much less than Obama to sever these linkages between politicians, cartels, and gangs in Central America, which has led to an ongoing and massive refugee crisis on the U.S. southwest border, particularly bringing the women, children, queer, trans, and impoverished people these criminal and paramilitary groups prey on. Title 42 expulsions have ensured that even those who would be eligible for asylum are denied the opportunity to petition. And now I have to go there. Indeed, refugee admissions are at a dramatic historic low, notwithstanding the presence of the kind of labor crisis in the U.S. that has historically resulted in looser immigration policies. Despite the fact that the administration recently agreed to raise the ceiling on refugees, virtually no one anticipates that after months of foot-dragging, the State Department will suddenly review applications quickly enough to get anywhere near the 62,500-person ceiling the administration recently set. While the Biden administration's decision to admit unaccompanied children may look like humanitarianism in this context, many activists have described it as just another child separation policy, forcing children to cross unaccompanied, leaving their parents in refugee camps and shelters in Mexico. The militarization of the border has also separated families since the Clinton era, and the ups and downs of things like temporary protected status, the need for migrant labor in certain segregated U.S. labor sectors, including agriculture, construction, domestic, and nanny work, continues to recruit workers, while the immigration system excluded children and elders, and ICE and Customs and Border Protection put Black and brown people in immigration detention, including children in family detention. Many of the children at the border have family members in the U.S. Ongoing drought, hurricanes, food system crises, and other climate change disasters have also contributed to forced migration and further separation of families and households. So, as we sort through activist responses to the Biden administration and the world's two simultaneous refugee crises, one from Central America and the Caribbean, and the other involving Kurds, Syrians, Afghans, and Iraqis, we might pay attention to the history of the taking of Native children. In the 1870s, the U.S. federal government began separating Native American children and taking them, under the watchful eyes of soldiers, to military-run detention centers, also known as Indian boarding schools. Legally, Indian boarding schools were the direct precursors of the detention camps that currently hold migrant and refugee children, as legal scholar Maggie Blackhawk has pointed out. The doctrine that established them has been cited by the second Bush, Obama, and Trump administrations to justify not only detention centers, but its entire conduct of the war on terror, insisting that it's exempt from judicial review because of what's known as the plenary power doctrine, which gives the executive branch, they say, unfettered power, specifically over Indian matters, but it's been extended to be over immigrant matters as well. And chillingly, Hitler was an admirer of the Indian boarding schools, and some have speculated that they were a model for the Third Reich's concentration camps. One Nazi legal theorist, Heinrich Krieger, wrote about U.S. federal Indian law just as the Nazis were drafting the Nuremberg laws setting out the special limitations on Jews, including stripping them of citizenship. Krieger concluded that the best way to understand the denial of U.S. citizenship to American Indians and the whole character of Indian law was to see it as a species of race law. And he wrote, The proper nature of the tribal Indian status is that of a racial group placed outside of the special police power of the United States. While this was not the only or the best way to understand, perhaps, the way that Indian law worked, it's clear that boarding schools could be understood as a special instance of race laws under federal police power. As Blackhawk argues, one problem is that, unlike some other race laws that have been overturned, like Plessy v. Ferguson and Dred Scott, and even the Korematsu case that allowed Japanese American internment during World War II has been cast as suspect, the plenary power doctrine is still good law that continues to be cited. Richard Pratt, a colonel in the infantry, was appointed to create Indian boarding schools while still in the military. From the federal government's perspective, Indian schools were to be places that would destroy children's Indianness, would kill the Indian to save the man, as Pratt famously said. Taking children as a means of ensuring peace, Pratt removed children from the plains and then from the Southwest to Pennsylvania, the Carlisle Indian School at Pennsylvania. He did, in fact, successfully put a final end to the Indian Wars by disrupting the passing down of indigenous languages and the reorganization of tribal nations. For a time, boarding school attendance was mandatory and forced by the military. Generations of Native kids spent time in them. However, activists finally successfully demanded an end to the taking of children and putting them in boarding schools. In the 1920s, an organized campaign that publicized the abuses of boarding schools finally demanded the attention of the government, concluding the era of legal challenges. Activists, lawyers, and eventually in the 1930s, government officials as well, fought to bring children home again. They insisted that tribal nations and individual parents had a right to determine what happened to their children, that children and youth should be educated in day schools on reservations, and that the boarding schools' high mortality, low rates of literacy, brutal work requirements, and inadequate nutrition militated for their immediate closure. Much of the visual archive about Native kids and their separation from their parents comes from photos like this one. Now let me click through. There we go. The photographer John Choate was commissioned by the Carlisle Indian School to take portraits of their students. The famous before and after photos of Native children at boarding schools that circulated like trophies among Anglo-Americans, even as they were used to persuade Native parents that sending their children to boarding schools would prepare them to negotiate with Anglos on behalf of their pupils. These pictures and others like them showed children shedding their beads and long hair and other trappings of so-called savagery for the trappings of civilization. They also showed changes in skin tone, and this is remarkably consistent across these photos. You can see that it appears that the children are literally becoming white. Indian boarding schools were originally proposed in the 1860s by the Indian Peace Commission, which was the first to argue for boarding schools as a way to end the Indian Wars. The U.S. federal government was warring with Plains tribes in order to secure frontier settlements, land for agriculture, mining and mineral rights, and to allow for the building of railroads. The commissioner's report actually described numerous social and legal injustices to Native peoples, including repeated violations of numerous treaties, settlement on their land, acts of corruption by many local agents, and the fact that employees of the railroad were shooting down indigenous people in wanton cruelty. However, the report also insisted that the root problem was, quote, the tribal or clannish organization, close quote, of Native people, and their failure to speak English, both of which they insisted could be remedied by boarding schools. tribal nations would be extinguished and Native children would become English speakers. The transformation in the U.S. approach to Indian policy, from warfare to schools that could exterminate indigenous languages and teach children to farm, however, was not finally accomplished until 1879, until after open warfare between the Lakota and the U.S. Cavalry that flared up again in a dispute over the Black Hills, sacred to the Lakota, in a war that included the 1876 defeat of the 7th Cavalry at the Battle of Little Bighorn, what we remember as Custer's last stand, or what we learned in school. Despite whatever veneer of humanitarianism may have cloaked the founding of boarding schools, their aim was not to educate children, but to make them a useful weapon in persuading indigenous people to end their warring over violated treaties. Pratt was chosen by the War Department because of his experience with American Indian prisoners in what was essentially the Guantanamo Bay prison of his generation, Fort Marion in St. Augustine, Florida. The Fort Marion prisoners came from the Red Hills War in Oklahoma in the Southwest and were considered singularly uncivilized and hostile. Pratt succeeded in pacifying them by cutting their hair, teaching them English, compelling them to clean and cook, and instituting military drills and tribunals in which some prisoners sent others to the dungeon, and forcing prisoners to attend church. He also participated personally in killing some of them. In 1879, while still on active duty, he opened the Carlisle Indian School, using many practices borrowed from Fort Marion, including the capture and incarceration of runaways to enforce his educational methods. Epidemics of cholera, influenza, and tuberculosis devastated children's numbers there, and many were buried at the school. This history is condensed in these two group photos taken at the Carlisle Indian Industrial School, in which show Apache boys and girls at the time of their arrival in November 1886 and 4 months after arriving in March 1887. This group belonged to the Chiricahua Apache Nation, whose leader, the famous Geronimo, had surrendered with his followers in Arizona at Cochise Stronghold in 1886, marking the end of the Apache Wars. The band, including 103 children, was taken prisoner and sent to Fort Marion, and then these children were then sent to Carlisle Indian School. Following what Anglo-Americans saw as the success of Pratt in the War Department, Christian missionaries and civil society Friend of the Indians groups began opening larger numbers of boarding schools in the 1880s to civilize indigenous people. In 1881, Congress declared school attendance for Indian children compulsory and authorized the Indian Bureau to deny benefits guaranteed by treaty if children failed to attend. They were to withhold rations, clothing, and other articles from those parents who resisted sending their children to school. Indian boarding schools spread through the West and Midwest. Before and after photos were popular throughout the United States to show the civilizing of Indian children. Removing Native kids was always linked to enhancing the wealth of non-Indians, particularly through attacks on the notion of tribal self-determination. The end of the Indian Wars opened up Native lands for extractive capitalism. The General Allotment Act inaugurated a massive grab for indigenous territories. Congressional and Bureau of Indian Affairs efforts allowed non-Indians to develop the natural resources of native lands, oil, water power, mineral resources, and tourism. The federal government, corporations like the railroads, and private individuals engaged in systemic violations of treaties. The U.S. federal government was empowered to act as a trustee for Native people, but it consistently failed to act in or even consider Native best interest in its role. There was also a conflict of interest inherent in locating the Bureau of Indian Affairs in the Interior Department with its role in managing and extracting natural resources. The process of separating Native children from their parents was often violent. One witness, writing in the 1930s, reported on conditions on the Dene Reservation, the Navajo Reservation. Quote, "In the fall, the government stockmen, farmers, and other employees go out into the backcountry with trucks and bring the children into school. The wild Navajos far back in the mountains hide their children at the sound of a truck. So stockmen, Indian police, and other mounted men are sent ahead to round them up. The children are caught, often roped like cattle, and taken away from their parents, many times never to return. Some, especially children who ran away, would be taken across the country and not returned until the age of 16 or 18. Close quote. Tribes, and occasionally even white lawyers in courts, were shocked by the violence of the Pratt system of Indian education and the removal of Indian children. In 1899, a federal district court granted a writ of habeas corpus to an Iowa tribe that forced the return of Native children from the Carlisle School in 1899, suggesting an alternative trajectory that might have ended boarding schools much sooner had it been followed. So I hold that up in part to say it wasn't just the times, right? There were opponents in every generation of this kind of child taking. It found that tribes had to consent to the removal of a child. Sometimes individuals withdrew their consent by running to Canada, though it too had its own residential schools, as we've recently been reminded by the finding of burial grounds on residential schools in Canada. Nevertheless, federal agents and missionaries continued to promote off-reservation boarding schools in some places until the late 1970s. Few Native children attended day schools or lived at home. Visits home were seen to impede the assimilation process and were discouraged as a matter of policy. Instead, children across the country were farmed out in the summers, boys working as ranch hands and farm laborers, and girls doing domestic labor. Scholars agree that regimens at the boarding schools were harsh. Children were punished, often beaten, for speaking indigenous languages. Dress was carefully monitored and checked by staff. Some scholars have suggested that sexual abuse of both girls and boys was rife in boarding schools. An investigation into comparable residential schools in Canada in the 1970s resulted in 3,400 complaints of sexual abuse. No similar investigation has taken place in the United States, although some have argued that any full inquiry into the crimes in U.S. Indian boarding schools would find not only sexual abuse, but starvation, medical experimentation, involuntary sterilization of girls, and physical punishment that amounted to torture. A 2012 survey of boarding school attendees found that nearly 30% reported that they had been sexually abused there. Yet there was one official inquiry into boarding schools in the United States that took it seriously as something that harmed Native children and communities. Throughout the 1920s, Indian policy reform advocates ran ever more far-reaching campaigns about the horrors of American Indian policy, including ongoing land theft, detribalization, and the suppression of Native culture, language, and religious practices, and insisting that child separation and boarding schools were the keystone of all the others. As a result of this public pressure, the Secretary of the Interior commissioned an independent investigation. The 1928 report, known as the Merriam Report, suggested that things were, if anything, worse than the press accounts had it. Its description of boarding schools were particularly powerful. Investigators found children living in overcrowded dormitories, sometimes without even adequate toilet facilities, subject to appalling health conditions, ill-clad, ill-fed, and ill-housed. Boarding schools operated below any reasonable condition of health and decency, in the words of the Merriam Report. It was rather strikingly echoed in 2019 accounts of conditions of refugee children in tents and warehouses serving as children's detention camps in Texas, where physician Dolly Lucio Sevier reported, quote, extreme cold temperatures, lights on 24 hours a day, no adequate access to medical care, basic sanitation, water, or adequate food, close quote. Children in Indian boarding schools suffered high rates of illness and death and were subject to a curriculum of little value. The report noted high rates of illiteracy. They had virtually no leisure time and were forced to do manual labor in support of the school, in apparent violation of child labor laws. The Merriam report urgently recommended that children be returned to their parents and communities. The continued policy of removing Indian children from home and placing them for years in boarding schools largely disintegrates the family and interferes with developing normal family life, its authors wrote. The Merriam report put pressure on the Hoover administration to close boarding schools, and its effect was electric, and was as close as the U.S. ever came to publicly repudiating Indian child separation policy. President Hoover immediately announced an increase in federal funding for boarding schools, for food and clothing for children. Within a few years, Hoover was voted out of office, and President Franklin D. Roosevelt appointed an Anglo activist in the Indian Reform Campaign, John Collier, to head up the Bureau of Indian Affairs, where he introduced significant changes designed to recognize tribal organization and laws that prevented the practice, to abolish laws that prevented the practice of native religion, including dances deemed obscene, and halt the reduction of the land base of Indian country. He also thoroughly irritated the traditional portions of many native nations by requiring a form of tribal government that included rule by simple majority, 50% plus one, rather than, say, 75%, which many tribes saw as an arbitrarily imposed standard that resulted in sharp factionalism within tribal nations. Collier also closed many boarding schools in favor of day schools, and in 1934, the federal policy requiring compulsory boarding school attendance was lifted. Still, some persisted into the 1970s, and a few boarding schools still exist, albeit with much revised missions. This was not the end, however, of the taking of Native children. Rather, in the 1950s and 60s, it shifted to foster care and adoption. The Indian Adoption Project and various state efforts to reform poverty, including the absence of indoor plumbing and electricity on reservations, by removing people's children from them, together with a conservative belief that Native women on welfare had babies just for the welfare check, led to the widespread taking of American Indian children. In Canada, they call this the 60s scoop. In the U.S., we remember it through the statistic that was used to campaign for the Indian Child Welfare Act of 1978. That 1 in 3 Native kids was in out-of-home care in the 1970s. And for a decade, the Indian Child Welfare Act, or ICWA, was quite successful in slowing child taking. Then came fetal alcohol syndrome, which pundits insisted was blighting a generation of babies. The sense of looming tragedy was met by a related effort to imprison Native women who failed to stop drinking during a pregnancy. The frenzy was launched by an autobiographical polemic, a book entitled The Broken Cord. Written by Native scholar Michael Doris, it was a memoir of his adopted son, whom he called Adam in the book, and who suffered from pervasive disabilities, which he said were caused by fetal alcohol syndrome. Published at the height of the sense of crisis about crack babies in 1989, the book told a painful story about the crashing to earth of Doris's hopes for his young son. The emotional story became a bestseller. It received unprecedented media attention, won a National Book Critics Circle Award, and eventually became an ABC TV movie. The book also helped popularize the belief that fetal alcohol syndrome was an emergency. Soon after its publication, with Doris as a star witness, Congress held hearings and passed legislation that labeled alcohol with warnings against drinking during pregnancy, which you still see. Doris's book became a touchstone for the question of fetal rights. Didn't those babies have a right to be born without disabilities? Both in the context of whether of those who drink during a pregnancy could be jailed, and in relationship to abortion politics. Indeed, Broken Cord framed those precise questions, organized by Doris's, quote, rage that Adam was not born whole, close quote. Doris never really accepts who Adam is, but takes refuge in the dream of a boy who might have been. Initially blaming himself for Adam's struggles, Doris doesn't relinquish the sense that someone is to blame, but moves on to his birth mother. Quote, my ultimate allegiance was to that person Adam was not allowed to be, to the baby carried by every woman who wouldn't or couldn't stay alcohol-free for 9 crucial months. This vision of a pregnant woman stubbornly clinging to drinking, even as it harmed a future child, builds throughout the book. Doris compares her drinking to an assault. If she had come after him with a baseball bat after he was born, he writes, if she had smashed his skull and caused brain damage, wouldn't she have been constrained from doing it again and again? Was it her prerogative, moral or legal, to deprive him of the means to live a full life? The book stops only just short of calling for the jailing of Native pregnant women who drink. Louise Erdrich, in her introduction, says that she would stop fetal alcohol syndrome any way I could, and argues in the language of law that Adam's birth mother had no right to harm her and our son. This is the logic from which incarceration flowed. The book's case for fury at those who drink during pregnancy also included harrowing statistics about its pervasiveness. 1 in 3 Native children had fetal alcohol syndrome, said Doris, echoing in reverse the debate over the Indian Child Welfare Act, while even the highest public health estimates put it between 50 and 100 times lower than that. As Lakota writer and feminist Elizabeth Cook Lynn suggested, the trope of the vanishing Indian was part of what people loved about the book, for, as she wrote, there seems to be no end to the interest that people have in declaring the Sioux dead or dying. Although alcohol is a legal drug, one that in fact is used more frequently during pregnancy by white people with college degrees than those who are not white or less educated, the moral panic around fetal alcohol syndrome contributed to the widespread criminalization of black and brown people, particularly women. One set of effects that were very much like those produced by the crack baby crisis, the production of a racialized underclass that was understood to be stunted from birth. Television and print media produced features that decried the child abuse and even genocide perpetrated by Native women, including a week-long segment on NBC in 1989 and called Tragedy at Pine Ridge. Pregnant alcoholic women, mostly Native American, went to jail to protect their fetuses, notwithstanding physician objections about the absolutely appalling miscarriage and stillbirth rates for women in prison. Mothers who drank lost their children to the foster care system. Native children with developmental disabilities were overdiagnosed with fetal alcohol syndrome. A 1994 genetic study on reservations in Arizona found that between half and 2/3 of the children diagnosed with fetal alcohol syndrome in fact didn't have it, that they had Downs or some other genetic developmental issue that would be entirely sufficient in itself to account for the children's developmental delays. But instead of looking to obvious medical explanations like Down syndrome, physicians turned to fetal alcohol syndrome as a catch-all diagnosis for children with developmental issues on reservations. In the book itself and in the wider cultural conversation that it engendered, there seemed to be little compassion for the person who carried Adam, a teenager who died within a couple of years of his birth from alcohol poisoning. As Doris and Erdrich did the rounds of media interviews and congressional hearings, no one seemed to suggest that the birth mother herself might have been a hurting child deserving of compassion. Native women on reservations were treated with particular harshness. Because the Major Crimes Act of 1885 gives the federal government prosecutorial power over violent crimes on reservations, a legacy of colonialism in the absence of native sovereignty, maternal drinking could be dealt with as a federal case and as a felony. For example, one teenage alcoholic mother of 3 was sentenced to almost 4 years in the federal penitentiary in Lexington, Kentucky, for nursing her baby while under the influence of alcohol. She lost her parental rights and her child was put in foster care. The mother was never offered treatment for her drinking or even medical care. Because the crime was being tried under federal jurisdiction as a felony, it was, absurdly, the FBI to whom she tried to explain her depression, her efforts to stop drinking, her efforts to refrain from nursing while she was drinking, and the baby's refusal of a bottle, her experience of rape at home and at boarding school, her inability to afford an abortion or find a way to travel several hours to Sioux Falls, to the only abortion clinic in the state. Rather than find in this troubled child's story a reason to get her help, the U.S. Attorney for South Dakota charged her with assault with intent to commit serious bodily injury, as if she had hit the baby rather than tried to care for it. If there was some hope that ICWA was going to ease the number of children taken off reservation into foster care and adoption, the broken cord and the alarm over fetal alcohol syndrome, the subsequent crises related to meth and opioids, made this promise more remote. The number of Native kids in out-of-home care declined for a time until the serial alarms over drugs and alcohol, and then it jumped to a rate higher than it had been before. This teenager's case suggests why. With the lone exception of a 4-part series in Indian country today under the title The Criminalization of Alcoholism, a Native Feminist View, there was no outcry over this case. The teen's attorney, her relatives and friends, and perhaps most poignantly, the girl herself raised no ruckus. In contrast to the 1960s and 70s, child-taking was normalized. Because of ICWA, the South Dakota State Department of Social Services had to work with the tribal council to terminate her parental rights, but that proved to be no barrier. As Cook Lynn wrote, the white man's law and the tribe's adoption of Anglo government have removed the traditional forms of punishment and control for criminal acts. If this case is any indication of law enforcement and justice on the reservation, it's a sad portrayal of the failure of the system and the subsequent loss of a woman's human and civil rights, and obviously of her treaty rights as well. The complex issue of Indian sovereignty, that is, the power of self-governance and the inherent right to control their internal affairs, is as much a subject of this discussion as is a woman's right to protection by the law. The interlocking problems of colonialism, misogyny, and racism put this teen and other Native women in jail, even federal prison, and foster care took their children. It bears pointing out that addressing poverty, inequality, and violence might have been much more effective in preventing fetal alcohol syndrome than criminalizing people who binge drink. Some studies have suggested that alcohol is only damaging to the fetus when the mother is malnourished, stressed, or exposed to environmental toxins. If one were to pick the best way to improve fetal outcomes from a public health perspective, it certainly would not be putting pregnant women in jail or prison. Jailing and imprisoning people does not ensure healthy outcomes for pregnancies, but it does cause people to lose jobs and stresses important relationships. It also exposes people to collateral consequences after a conviction, from making it hard to rent an apartment to excluding people from jobs and careers. Those who engage in binge drinking during pregnancies are already in terrible pain and trouble in their lives. According to some studies, most of the mothers who give birth to infants affected by fetal alcohol syndrome are dead within a few years as a result of violence or alcoholism. Meanwhile, state governments that allow lead to poison the water, as in Flint, Michigan, causing miscarriage rates to skyrocket, or fossil fuel companies that pump carbon dioxide into the air and make the climate unfit for humans, cannot even be said to be committing a crime, even though they cause far more widespread harm. So, whether we're talking about Native peoples or asylum seekers and immigrants, we need a different conversation about the separation of children from their kin and caretakers, one grounded in the histories of how we got to camps on the southwest border for Native peoples and then for Central Americans. This is also actually where many Afghan refugees are being held at the moment. There is in this hemisphere a powerful racialized haunting, generation upon generation of children who have lost parents and parents' children. Separating children from parents is more than just another version of a larger mistreatment of immigrants and asylum seekers or enslaved and indigenous peoples. Taking people's children participates in a very brutal kind of political punishment, a symbolism in reality that is meant to be starkly tangible, crude, and cruel. By its own account, the Trump administration took the children of Central American asylum seekers in an effort to terrorize them into staying in Guatemala, Honduras, or El Salvador, or withdrawing their petitions for asylum for those who had already filed them. The international asylum system functions only to the extent that people are able to request refugee status. Despite the Trump exceptionalism that's led many people to believe that refugee child separation is new, Central American children have been sent to detention camps and separated from their parents in the United States for decades. Mexico, Central America, and the Caribbean came in the early 20th century to function as a kind of labor reserve for the United States. Agribusiness, service industries, and the construction sector in the United States, alongside employers of housekeepers and nannies, relied on being able to access a labor force that, under the shadow of deportation, could be expected to work cheaply and outside the legal system of labor protections like minimum wage. In times of labor supply, these workers could be pushed back to Latin America. In times of shortage, more could be recruited. The arrival of large numbers of children signaled the end of this tacit bargain. The deal was essentially that workers would not stay in the United States, and employers and local communities would not pay the costs of reproducing the labor force. Children would stay in home countries to get educated, get their health care, and grow to an age where they could be of use as workers. When people became too old or disabled to work, they could also be forced back across the border. In this way, Latin America functioned like South Africa's homelands, or Bantustans under apartheid, a reserve where women, children, and elders were expected to scratch out whatever subsistence they could off a workers' remittances, or whatever land they could find to farm. In the 1980s, this system began to falter in Latin America as region-wide anti-communist wars forced many to flee their home countries. Women became a larger percentage of migrants, often bringing children across the border as well. By the 1990s, with the Clinton-era militarization of the border, this system broke down even further, as workers could no longer return to home countries to birth or father children, renew relationships with a child or with partners, or visit elders as they lay dying. Throughout the 1980s and 90s, legal cases wound their way up to the Supreme Court, asking whether asylum-seeking children could be held in detention. By 2014, when Central American children started arriving unaccompanied, it was clear that the border militarization and deteriorating conditions of violence victimizing impoverished people in the region had destroyed the old system. Unaccompanied children began filing asylum petitions in large numbers for the first time after 2000, claiming a right to safety as drug cartels, police violence and impunity, economic collapse, and gangs threaten their well-being in order to continue to feed the apparently insatiable appetite for drugs in the United States. U.S. policy continued to try to keep the old labor agreement in place. Its collapse was why conservatives and white nationalists were and are in a dead panic about small children crossing the border. Throughout the 80s and 90s, Reagan and the first Bush administration aggressively defended the practice of holding about 2,000 children a year. They sought to keep detaining children even after the Ninth Circuit ruled that they had to release them, until the Supreme Court in 1993 ruled that children had no right to be free of detention. In his dissent, Justice Stevens insisted that, on the contrary, jailing children for offenses that were only as legally weighty as a parking ticket were obscenely punitive. During the Clinton years, little changed. About 200 children were being held in long-term immigrant detention at any given time, and a human rights report damned the practice of jailing children, particularly those who were lawfully present in the U.S., because they had applied for asylum. It called on the INS to release children, and the Clinton administration was ultimately quite embarrassed by this and agreed to the Flores Agreement. Last year, and particularly with the COVID-19 crisis, the Trump and then Biden administrations began to actually accomplish what W had set out to win, the effective unraveling of the asylum system put in place after World War II. After March 2020, ICE gave very few people their due, their right to an asylum hearing, but metered their crossing into the United States and then sent them back across the border into Mexico to live in UN-funded refugee shelters and tent cities to await hearings that never came. And as we've seen, even these limited forms of access to refugee hearings have been reduced to the merest trickle. We will continue to need an asylum system to address the aftermath of wars and corruption in Central America and the Caribbean. Decades of intervention by international financial institutions, the World Bank, the Inter-American Development Bank, donor nations and non-governmental organizations or NGOs to shrink and replace the functions of federal governments in Central America have, by design, dramatically weakened Central American and Caribbean states in order to promote free markets. So I want to conclude by way of this image of a protest at Fort Sill, where the Trump administration sought to house 1,600 immigrant children. Fort Sill began as a prisoner of war camp during the Indian Wars, where the Apache leader Geronimo died. A century later, it housed Japanese American detainees during World War II. And then this group, a coalition of members of the Movement for Black Lives, Japanese, Jewish, and Native activists, stopped it from becoming a detention facility for migrant children. As we watch as the Biden administration tries to figure out whether it will continue to expel tens of thousands of people, and it is, or honor its campaign promise to listen to what the majority of people in the United States say they want when they're talking to pollsters, which is actually increased immigration, a just and rapid asylum system, and a pathway to citizenship rather than a racialized labor system, that consigned some people to exploitative jobs in fields and people's homes, threatened always with the risk of losing their children in order to keep them in line. We need to honor the history of protest against child taking and remember that people in every generation have stood against it. Thank you. It's a really interesting question. So most historians tend to focus on government-run boarding schools because in some ways they're the easiest to trace. They're the subject of federal policy. But we see Protestant missionaries, we see Catholic missionaries, we even see Mormon missionaries setting up boarding schools. And so far as I can gather, and one of the interesting things about things we don't know, we don't even know how many boarding schools there were in the United States, is that it seems like fewer than half of them were government-run boarding schools, but it also varied over time. It's kind of extraordinary. When you, I understand this in some ways best from talking to lawyers who were involved in the original investigations of how children were taken before in the sort of campaign that was the run-up to the Indian Child Welfare Act in 1978. I really got a sense of how much impunity people felt they had when they were on Indian reservations, that they could literally just walk into somebody's house and take their children. And obviously people resisted this, and not everybody was like that, but nevertheless, that sense that there was no law that anyone was bound to respect, including churches and the government, is kind of horrifying and riveting. So somebody should go get that job, because a lot of us want to know a lot more. It's something about how the pictures were developed or how they were lit. So this is 1879. It's early in the history of photography. And perhaps people are also living more inside, but these are a few months apart. So it's something about how the photography was taking place. But it's just fascinating to me to look at them in that light, because, so to speak, because it was so explicitly the goal of Indian policy at this point to really turn these kids into white people. I mean, on the one hand, these are artfully composed. You can see that you can find tons of these pictures on the internet because they're public domain, and so lots of people have scanned them. And on the one hand, you can see an effort like to recompose them as if they were, so people are standing in relatively the same position to each other. And in terms, and like this one, you can see in the, it's your left hand too. In the left-hand photo that folks are outside, and in the right hand, they're in some kind of studio. But that one, for example, those are clearly both studio photos against a background. And, you know, on the one hand, the photographer knew what he was going for. And on the other hand, I never want to attribute to conscious design what can be attributed to unconscious design. So somebody should find that out. Thank you.